Is calling 2025 CR 002103, State versus Jeffrey Patrick Smith. Can I have parties announced?
Tilden Schaefer for Mr. Smith, Your Honor.
Kurt Grancy, co-counsel with Tilden Schaefer.
All right. Counsel, have you received all discovery and did you review it with your client?
We have and we did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smith, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it? It happens. Did you review the true bill of indictment with your attorney?
And here we go. The judge is about to walk us through one of the most misunderstood processes in criminal court, deferred adjudication. Pay attention to how many questions she asks. This isn't small talk. It's the court making absolutely sure the defendant understands every right he's giving up. One wrong answer, and the whole plea deal could fall apart.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You're not.
Any objections?
No, Your Honor.
Did you review the court admonishments with your attorneys? Did you understand it and sign it in all the appropriate places? Did you understand in count one, you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. Range of punishment. Just 1 second. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine. State is proceeding on count one only. There's an affirmative finding of deadly weapon. There's no application for community supervision. You don't qualify for community supervision legally. There is an application for deferred adjudication, and the state is recommending deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
None ruled on, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with the complainant, MRT, anger management, driver safety and gun safety courses, forfeit the weapon and horseshoe bay badge credentials, no firearm possession, no law enforcement employment. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense in count one, how do you plea? State, any evidence?
State offer states exhibit 1.
No objection, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, first, why should I follow this plea bargain agreement?
Personally, and he would like to.
Okay. Anything from Vince?
Judge, I think this is a situation where my client greatly regrets what he did. It's a situation that got out of control. And I think based on his background and age, it's one of those, we should have made much wiser decisions. He doesn't have a violent background. And I do know, and I think the court can tell from how he's answering questions, there's quite a bit of regret in this entire affair, Your Honor.
All right. So why did it come to this?
Your Honor, it was just a messed up situation that night. I wish I could have made a different decision. You know, my son was in the car with me. I was worried about his safety 100%. And on a minute that hasn't gone by since this has happened, that I wish I could have made a better decision that night.
Okay, I understand what you're saying, but I still don't understand how an argument on the road comes to a pulling of a weapon. I just don't understand that. And they're asking for a driver safety course. They're asking for a gun safety course. They're asking that you forfeit your Horseshoe Bay badge credentials. And they're saying that you flashed a badge and that you were no longer employed with them. So I'm just trying to figure out what conditions would be appropriate for you. This is why I asked these questions, because
I only
there's a lot listed.
used the old time to diffuse the situation. I thought it would help. That was it. There was no other reason behind it.
Why did you still have the badge?
It was given to me by my chief of police at the time as a memento, because that was my first job there before I went to Border Patrol.
So where do you work now?
I've left I left Border Patrol in 2016. I went back to construction. I'm a home inspector for new homes. Till this happened.
This is where the courtroom tension spikes. Notice how quickly the judge zeroes in on the badge and the weapon, because flashing authority and then pulling a suppressed handgun isn't just a lapse in judgment, it's a legal earthquake. And the defense? They're trying to build a narrative of fear, misinterpretation, and split-second panic. But the judge clearly isn't buying everything.
I was planning on going back to actually apply for ICE. That's null and void.
I mean, but here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
No, so Judge, he has a suppressor, and so his parents live near Kerrville.
Okay.
That's what the mother and father, they had gone out to her birthday celebration that night. He was going home with his son. And they have it's in a rural area, so they actually have kind of a setup where they do target practice. The suppressor has more to do with not making loud bangs. That's why he had, and it's legally owned. He's got the stamp for it. I have it in my file back, trial file. It's not illegally possessed. Otherwise, I guess the feds would be involved in this case, Your Honor. That's why I had the silencer. I can tell you that there was a perception on my client's part that the kid was tailgating. Then there was a brake check, which you can see from the statement and the police reports. And then the kid comes around really close, rolls down his window, honks at him, yells, starts cussing, and it kind of goes from there. It goes kind of south. I think my client thought he could handle the situation. He thought he would diffuse it with the badge. That didn't work. And then at the moment when this all happened, apparently the young man had a phone in his hand. This was at night, and he made a gesture kind of with his hand to the side, which at that moment in time, my client, who was already kind of freaked out, thought it was a gun. And this was an apparent danger case, Your Honor. Police didn't find a gun in the kid's car, but that's what we saw. We actually, in the subpoenas, dug up extraneous acts where a kid had got in trouble at school for posting shots on social media with him with guns. And he's holding it the same way he was holding the phone. When he's talking to the police officers, he's holding it, he's pointing like this. So that's the gesture my client saw in that moment. He made a mistake. We've spent a lot of time on this. The state has spent a lot of time. They showed us a new witness who was the girlfriend of the young man in the car at the time that nobody had ever found. We'd always wondered, why weren't they looking for the girlfriend? We couldn't find her. We didn't know her name. Ms. Alban did a great job preparing for trial. And that's kind of why we're here today, Judge. I think both sides have kind of met in the middle. Again, my client doesn't have a violent background. It's just thank God that he didn't hit the kid. So that's why we're here.
Oh, is there something else?
Well, I mean, I'm not sure it's clear. The gun was in the car because of going out target practicing, but he had
Right.
gone and met his family for dinner, and he was going home, and they were in the back seat of the car, in a bag. You know, it wasn't as if he routinely carries a gun.
He had been target practicing at his parents' house prior to dinner. He actually had a concealed carry permit, which he's since had to relinquish. The state revoked because of this.
Is there anything else?
No, Your Honor.
Anything else from the state?
Defendant is happy with this resolution. I would, the court would like to hear now, I do have a restitution amount put on the judgment. If you would like.
Yes.
It's $2,463.82.
I'm sorry,
Okay.
just 1 second. If you could repeat that?
$2,463.82.
So is there any disagreement on that restitution amount?
No, I think that was part of the discovery. We actually had the receipt from the repair shop, Your Honor.
And where will you have that restitution amount?
Judge, I think it's going to take a couple of months if the court would entertain that. He started this job about June, maybe, and so there's been some lag time. And I mean, he is the independent contractor, so lag time in taking the jobs and getting paid.
All right, just 1 second. Excuse me. Everybody on this side, y'all need to move because probation can't see and they can't hear what's going on. All right, so when do you think it will be? Oh, and state your excuse. When do you think he will have that?
If I had, I would say a minimum 2 months.
Yeah, 60 days.
All right. And that's 60 days from today? All right, this is what the court is going to do. The court, and I'm going to tell you, I was considering sending you to jail as a condition.
Okay, this is a moment everything hinges on the sentencing. The judge has heard the explanations, the excuses, the context. But does remorse outweigh risk? Does a clean record outweigh a bullet fired in fear? This is where your instincts kick in. What would you decide if you were sitting in that chair?
But the state is saying that the complainant is in agreement to this being your sentence. So you can thank the complainant for that. Because sometimes I feel as though people need to have a chance to be alone in their thoughts at the jail to consider everything that is what they've done.
And there it is, the judge's version of a life lesson wrapped in dry humor. Judges do this often. They slip real-world advice between the legalese, reminding defendants and all of us watching that sometimes tragedies start with the smallest, pettiest decisions.
And it appears that you've taken that into consideration. And it appears that on this night, everything that could go wrong did go wrong. But don't brake check people. People don't like to be brake checked. That's just my experience from driving. All right, 5 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. And I'm sorry, what do? You said you in construction?
Yes, ma'am. New home inspections.
All right, he can do regular random UAs, or either you can do the patch. The patch costs more, but with the patch, it gives you more freedom because probation will put it on and probation will take it off. Patch costs more though. So you can either do regular random UAs or the patch. Proof of employment within 45 days. There's to be no employment as a home healthcare provider with minors. 120 hours of community service restitution. I'm going to require parenting classes. Once you complete that, the community service hours will be deemed satisfied. MRT, the anger management course. You're to forfeit the weapon, and you're to forfeit your horseshoe bay badge credentials. There's to be no firearm possession. There's to be restitution in the amount of $2,463.82 to Joseph Pettis, and that's to be paid in full within 60 days. There's to be no contact with Joseph Pettis. There's to be no employment with law enforcement or any type of security. There's to be field visits 1 time per month for 6 months. Are you here in Bear County?
Yes,
All right. Probation, is there anything else? All right, and I'm sorry, there's a $1,500 fine that will be probated. Is there anything else that you need from the court?
Yeah, Judge, in regard to employment, if some of the jobs are out of county, I know some are in contiguous counties, but if they're further, can he get permission to do that if he shows probation where he's going?
Yes.
Okay.
Probation, he's allowed to work throughout Bear County and other counties, but you'll need to provide notification to probation that you're going to be working out of county. Working in county, that's fine. But if you're going out of county, you need to let them know. All right, is there anything else?
And I just, and actually part of the plea bargain was actually to not only just waive, but to actually dismiss the set count too. I don't know if that was clear. You did do it, you waived it, but that is part of the inducement for the plea is that, and it was to be.
Oh, I've already said that it's been waived. It's on the record.
No, I understand that, but I'm just being hyper-technical.
No. I understand what you're saying, but I put on the record that
Yes.
it was waived and you all had no objections to it being waived.
Correct,
So
correct.
it will not come back.
Okay.
It's not allowed to come back.
There you go.
'Cause-
That's what I
All
want.
right, thank you.
Sorry.
No problem.
All
Did you, and I'm sorry, there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, communication with probation is key. If there's an issue, you need to let them know about it. If you feel they're not addressing it, you can always come back and address it to court. But whatever you do not disappear on probation. That's not a good look. You understand? All right, good luck to you.